Anatomy of a False Statements Prosecution in the D.C. Circuit Courts, the Scooter Libby Trial. A program planned and developed by the Historical Society of the District of Columbia Circuit and the D.C. State Committee of the American College of Trial Lawyers. The program took place in the Court Ceremonial Courtroom on June 10, 2026. The program features informative dramatizations of 5 key parts of a false statements case: an FBI interview, a pre-indictment meeting between the prosecutors and the U.S. attorney discussing whether the case should be brought, the judge's thoughts when the case was assigned to him on how to deal with intense media interest, jury selection, and public statements by the litigants, an overview of the defense team's strategy and tactics, and a dramatization of possible jury deliberations based on actual juror notes and post-verdict juror interviews. Carrie Johnson, award-winning Justice and Supreme Court correspondent at NPR, narrates the program. 12 highly regarded attorneys, including several participants in the original trial, along with the original trial judge, Judge Reggie B. Walton, take part in the dramatizations. The defendant, Louis Scooter Libby, was convicted on 4 of 5 counts by the jury after 8 days of deliberation. But first, an introduction from the president of the Historical Society of the District of Columbia Circuit, James E. Rocap III.
Good afternoon. My name is Jim Rocap, and I happily serve as the president of the Historical Society of the D.C. Circuit. On behalf of the Historical Society and Steve Raber, president of our co-sponsor, the D.C. State Committee of the American College of Trial Lawyers, we welcome you to this, the 4th program in the series of Judge Patricia Wald programs on life and law in the courts of the D.C. Circuit. Before I turn things over to our moderator, Carrie Johnson of NPR, I do want to thank the chief judges of the courts and especially the courthouse staff for making this event possible. And I would also like to thank all of our very distinguished panelists, participants in the program this afternoon. For those of you who do not know them, read about them in the program. It's a very distinguished group of attorneys, and we're very happy to have them all participating, and thank you for the work that you've done to get ready for this program. And I'd also like to give a special thanks to Judge Reggie Walton, who is actually currently presiding over another criminal trial right down the hallway, for carving out time to be with us this afternoon. We appreciate it, Judge Walton. Thank you. And finally, what should be obvious, but I will do it anyway, I'm going to have a disclaimer here. The program, by necessity, is a distillation and dramatization of certain events before and during the trial. It is not, and does not purport to be, a verbatim recitation of the actual events at trial. It is a distillation and dramatization of events. Only in 2026. At any rate, with that, Carrie, the floor is yours. Thank you.
Thanks so much, Jim. It's an honor to serve on the board of the Society and be here today with this distinguished group to relive such a dynamic moment in our legal history. Some of the people you're going to hear from this afternoon have firsthand experience with this case as members of the prosecution team or the defense, and as the federal judge who presided over the case. You can read more about them, as Jim said, in your program. Before we bore down into the details, let's set the scene. In January 2003, the government led by President George W. Bush was marching toward war with Iraq. In his State of the Union address that year, President Bush said, "The British government has learned Saddam Hussein recently sought significant quantities of uranium from Africa." Those 16 words set the stage for a deadly conflict that would span nearly a decade. And they helped give rise to the court proceedings you're about to observe. Weeks after the State of the Union, the U.S. struck Iraq, based on the idea the country was concealing weapons of mass destruction. Soon after, media reports began to question the basis for launching those strikes. One of those reports was a May 6, 2003 article by Nicholas Kristof in the New York Times. He described how, at the request of the Office of Vice President, a former ambassador, later identified as Joe Wilson, traveled to Africa early in 2002 to run down rumors Iraq had been trying to buy yellow cake uranium. But that almost a year before that State of the Union speech, The former ambassador reported to the CIA and the State Department those allegations were false, based on phony, forged documents. What that meant for America's case for war and claims about Iraq and WMD would be profound. On July 6, 2003, Wilson went public himself with his own op-ed in the New York Times. He wrote about what he did not find in Africa. Wilson said there was no truth to the idea Iraq had tried to buy that uranium. Like the earlier Christoph article, Wilson stated his mission to investigate the Yellow Cake story was undertaken at the request of the Office of Vice President Dick Cheney, and he expressed confidence that the Office of Vice President would have been provided with his report. He accused the Bush administration of exaggerating the nuclear threat to justify the war in Iraq. Not long after, columnist Robert Novak disclosed Wilson's wife, Valerie Plame, was a CIA operative who might have dispatched Wilson on that trip to Africa. The central question all over Washington soon became, was Valerie Plame outed in retaliation for her husband's disclosures? It also became a legal question because it would be against the law for a government employee to disclose the identity of an undercover operative. By September of that year, 2003, the FBI was on the case. One of the people they interviewed was Louis Scooter Libby, Chief of Staff to Vice President Cheney. Federal agents questioned Libby on October 14th and November 26, 2003. That winter, Attorney General John Ashcroft recused himself from the investigation, citing his close ties to the president who appointed him. That recusal meant Deputy Attorney General James Comey would be in charge. Comey saw the potential for conflict, too. He promptly named his one-time trial partner, Pat Fitzgerald, special counsel to preside over the investigation. Now, behind the scenes, the FBI learned something important that December. It was a fact that would not become public for more than a year. Agents who were digging into the disclosure of Valerie Plame's identity learned that Deputy Secretary of State Richard Armitage was the source for the columnist. Armitage had told the FBI he shared the information with Robert Novak. But the public did not know that, and the investigation continued. In addition to Novak's article, separate stories in Time magazine and the Washington Post had referred to government officials disclosing information about Valerie Plame, and it wasn't clear who the source was for those articles. Nearly 2 years later, a grand jury in this courthouse handed up an indictment. The case was United States versus Louis Libby, also known as Scooter Libby. 5 counts that included obstruction of justice, false statements, and perjury. There was no charge of making an illegal leak about the identity of a protected person, a CIA operative. No evidence was ever offered that Plame was covert. The defense would have argued to the contrary, but the judge ruled it was irrelevant. Instead, all the charges centered around statements Libby made in FBI interviews and under oath in the grand jury about his conversations with journalists for NBC, Time magazine, and the New York Times years earlier. So that's the backdrop of this remarkable case. Now, you're going to hear more about Libby's meetings with the FBI. Back in October and November 2003, Libby met with federal agents twice. He talked about Valerie Plame's connection to the CIA and about his chats with reporters about Joe Wilson's trip to Africa. We're going to sit in now on a recreation of a portion of those interviews.
Good afternoon, Mr. Libby. Thank you for coming in. I'm Special Agent Kirk Armfield.
And I'm Special Agent Deborah Bond.
As you know, we're interested in what you know about the disclosure of the identification of Ambassador Joe Wilson's wife as a CIA employee. But first, please tell us your name and current employment for our record here.
Yeah, so my name is Louis Libby. I have a nickname, Scooter. I'm the National Security Advisor and the Chief of Staff for Vice President Cheney.
Let's focus on the time before the Novak article on July 14th, 2003, that disclosed that Ambassador Wilson's wife was a CIA operative. Tell us about discussions you had with other government employees during that time about Ambassador Wilson's trip to Niger, the role that his wife may have had, and her employment with the CIA.
All right, well, first of all, I don't think it needs to be said, but I'm going to say it anyway. There was a lot going on at this time in the White House and in the office of the Vice President. I mean, we had invaded Iraq in March, and by summer, the insurgency was ongoing, and we frankly hadn't really planned for that. So I was very busy. I had a lot on my plate, and frankly, this was not the most important thing that I was dealing with. Having said that, I'll try to do my best to tell you what I remember.
Look, that's all we're asking you to do. Just tell us what you recall about conversations with the government about the ambassador's trip to Niger and any role that his wife might have had.
Well, the most important thing was we wanted to push back on the narrative that emerged from the May 6th Nick Kristof article in the New York Times that said that the Office of the Vice President was responsible for sending the envoy to Niger. That was false, and we wanted to correct it.
Did you talk to the Vice President about how to do that?
I know that I had, from recently looking at notes that I have, I know that on June 12th, I spoke on the phone with Vice President Cheney where the topic came up. I'd forgotten about that conversation until I just recently reviewed my notes in preparation for this interview. And the Vice President and I discussed, according to my notes, how to respond to questions from the Washington Post about for an upcoming article that they were writing.
What do you recall the VP telling you?
Well, he had somehow learned from the CIA that the CIA and not the Office of the Vice President had arranged for the envoy to go to Niger. I don't believe Vice President Cheney knew the name of the envoy or the identity, but my notes say that he believed the envoy was married to someone with the with the CIA, who had been who was in the Counter-Proliferation Division. It was clear to me that Vice President Cheney wanted the public to know that the White House did not know about Wilson's trip, didn't have any role in arranging it, didn't get a report from the mission, and did not know that the conclusions about Iraqi attempts to purchase yellow-cake uranium were based on forged documents.
So it sounds like you knew, at least as early as June 12th from your conversation with the VP, that Wilson's wife was a CIA employee in the Counter-Proliferation Division, right?
Well, yeah, but as I told you, I only remember that from looking at my notes from the last couple of days preparing for this interview. I'd completely forgotten about that at the time.
On July 6th, the New York Times published an op-ed article by Ambassador Wilson. Wilson wrote that during his trip to Niger, he found no evidence that Iraq had obtained uranium from Niger. Wilson also said he believed the Office of the Vice President had initiated the CIA's investigation into the report about uranium being sent from Niger to Iraq, and that the Office of the Vice President was advised of the results of this trip. What was the reaction of the Office of the Vice President to Wilson's op-ed?
Well, look, the Vice President was very upset about the fact that Wilson was claiming that the Office of the Vice President was behind his trip to Niger, because that wasn't true. We talked about what to say to the press in response to Wilson's article. There were many conversations between the CIA and the White House regarding what to release to the media responding to Wilson's claim. And there were a number of press releases from the CIA, from the Office of the Vice President, and from the White House, disputing Wilson's claim that implicated the Vice President in the trip.
Do you recall any other specific conversations at this time within the government about Wilson's wife's role?
No, as I think about it now, I can't recall anything else.
What about Ari Fleischer, the White House press secretary? Do you remember a discussion with him about Joe Wilson and Wilson's wife?
Well, I had lunch with Ari Fleischer. It was his going away lunch. I think my calendar says it was July the 7th, and as he was leaving the administration. And, I think probably the subject of Wilson's trip did come up in the conversation, but I don't recall any of the specifics. I can tell you, though, that I'm sure that there was no mention of his wife. And quite frankly, I got to tell you, the only thing I really remember about that lunch is we talked about the Miami Dolphins.
Well, what about discussions with Robert Grenier at the of the CIA?
I recall talking to Grenier at some point. I'm not sure whether we spoke about the press articles relating to Wilson.
Well, did you ever speak with Kathy Martin in public affairs about the role of Wilson's wife?
I don't recall any specifics about conversations I've had with Kathy Martin.
Then let's talk about conversations you had with others outside the government, for example, with the media.
So I recall that Chris Matthews on Hardball, his Hardball show, discussed Wilson's article. He wondered why, if the vice president knew about Wilson's trip, the vice president didn't tell President Bush about this before the State of the Union address. And I was very upset because Matthews publicly stated that the office of the vice president requested the Niger trip while implicating me and the vice president. I believe the media was being misled, so I wanted to get a correction. I didn't really know Chris Matthews, but I did know Tim Russert at NBC. And so I thought I'll reach out to Tim Russert to see if I can get his help in getting Chris Matthews to make a correction.
Did you talk to Russert?
Yeah, I spoke with Russert, I think it was July 10th or 11th of this year.
Tell us about that conversation.
Well, I told Russert that Vice President Cheney did not request the Niger trip and asked if he could do anything to get Chris Matthews to issue some sort of correction or to correct what he said. He said he really couldn't help us.
Was there any discussion relating to Ambassador Wilson's wife?
Yeah, as I remember it, Russert asked me if I was aware that Wilson's wife worked for the CIA. I told him I didn't know that. He said, well, all the reporters know it. Well, this was a surprise to me.
But don't your notes, June 12th notes about your conversation with the vice president, make it clear that Vice President Cheney had told you that the individual who went to Niger was married to a woman who worked at the CIA in the Counterproliferation Division?
Yeah, but like I told you, I had forgotten that conversation until I just looked at my notes, a couple of days ago.
Well, frankly, it just seems odd that your conversation with Russert would not have jogged your memory that you had heard the same thing about Wilson's wife working for the CIA just a month before in your conversation with Vice President Cheney.
Well, like I told you, I was really busy at this time. There was a lot going on besides the story about who was married to whom. And remember, my focus was on correcting the inaccurate reporting, namely that it was our office, the office of the vice president, who sponsored Joe Wilson's trip. Who Joe Wilson was married to really was not very important.
Okay, let me look at my notes here. So to make sure we understand what you're telling us, in July of this year, and really until a couple days ago, when you reviewed your notes of the June 12th conversation you had with the vice president, you believed the first time you ever heard mention of Joe Wilson's wife as being employed by the CIA was when, as you recall it, Tim Russert volunteered that information to you, telling you it was well known among reporters.
Yeah, that's right.
Did you talk with any other reporters about Wilson's trip where Wilson's wife was part of the conversation?
Yeah, sometime after my conversations with Russert, CIA Director George Tenet released a report that disputed Wilson's statement regarding the involvement of the Office of the Vice President in his trip to Niger. On a flight on Air Force Two on July the 12th, Vice President Cheney told me we had to make sure the press was aware of Director Tenet's statement.
What did you do as a result of that conversation?
So I made at least 3 calls to reporters after we landed on July the 12th. I was able to reach Matthew Cooper of Time magazine. I spoke to him from the airport lounge at Andrews Air Force Base. I read verbatim to him the talking points that I had discussed with Vice President Cheney. The topic of Wilson's wife came up when Wilson asked me how Wilson got selected. I told Cooper that reporters were telling the administration that Wilson's wife worked for the CIA. I said I didn't know if that was true. I didn't mention any specific reporters' names.
Why did you tell Cooper about Wilson's wife?
Well, so we would understand if Wilson's wife worked at the CIA and had anything to do with Wilson going on the trip, perhaps his wife may have given her husband misleading or inaccurate information.
Well, is there anything else you recall about that conversation?
Cooper asked why Wilson was continuing to claim that the Office of the Vice President sent him on to Niger if the Director Tenet and the Vice President were saying it wasn't true. I told him I didn't know the answer to that question. I was trying to steer reporters in the right direction and not generate a story about his wife.
Any other reporters?
Well, I recall I spoke with Judith Miller of the New York Times on July the 12th. I told her I had heard from that other reporters were saying that Wilson's wife worked for the CIA. I said I didn't know whether that information was true.
Mr. Libby, is there anything else you'd like to add to what you've told us today?
Yeah. In my conversations, I was very clear to say that reporters are telling the information about Wilson's wife, because in my mind, I didn't know that that was true. All I had was this information was coming from the reporters. I wanted them to understand it wasn't coming from me. They couldn't look at me as the source of the information. So I wanted to be clear. They didn't think it was me saying it. I didn't know if it was true, and I wanted them to understand that. So I tell a couple of reporters what I've heard from a couple of reporters. I don't think that's a crime.
The prosecutors in charge of the investigation focused on those interviews with the FBI and Libby's later grand jury testimony. No one was ever charged for actually disclosing classified information. And of the many people involved, only one government official was prosecuted, Scooter Libby, for obstructing justice. Pat Fitzgerald, the special counsel appointed to lead the case, met with his team to make a final call. Let's sit in on a synopsis of the deliberations. You'll hear what prosecutors saw as the strong points in their case and discussions about challenges they might face at trial.
All right, Peter, Katie, what do we have?
Well, in the course of our investigation into who leaked Valerie Plame's name to the media, we learned that over a period of 4 weeks, Scooter Libby had 9 conversations with 7 different individuals about Valerie Plame. When we talked to Libby about this, he claimed not to recall any of those 9 conversations. He had no memory of them. He said he learned about Valerie Plame from Tim Russert, a conversation he had with him over the phone. We spoke with Tim Russert. Tim Russert said he never told Scooter Libby anything about Valerie Plame because he himself did not know that she was affiliated with the CIA and did not know who she was. So I want to take you through these conversations one by one. So the first conversation of note was with Mark Grossman, the Undersecretary of State. Libby asked about the ambassador, Joseph Wilson's trip. Grossman reported back that Wilson's wife worked at the CIA. This was on May 29th, and this was the first of these 9 conversations. Second conversation was about 10 days later, on June 11th, with the Vice President. The Vice President, Dick Cheney, told Libby that Wilson's wife works at CP. CP stands for the Counterproliferation Division. Libby wrote this down in his notes, which we have. So we know definitively on June 11th, this was information he learned from the Vice President. That same day, June 11th, Scooter Libby talked with the CIA Iraq mission manager, Robert Grenier. Libby pulled Grenier out of a meeting he was having with the director of the CIA. This was an urgent matter. Grenier left the meeting and had a phone call with Scooter. He told Scooter Libby he confirmed for him that Wilson's wife worked at the CIA. This was the third conversation, and the second on June 11th. Later that same day, June 11th, Kathy Martin, the assistant to the Vice President for Public Affairs, told both Scooter Libby and the Vice President that Wilson's wife worked at the CIA. So that was 3 people on the same day, June 11th. The following day, Mark Grossman, the Undersecretary of State, whom we spoke with on May 29th, had done some digging because he wanted to do further investigation to see if there was more to the story. So he called Scooter Libby back and he gave him a more fulsome report. And he told him that Valerie Wilson worked at the CIA and had a role in sending her husband to Niger. That was the 4th conversation in 2 days. 2 days later, on June 14th, Scooter Libby was getting his classified presidential daily brief, which he got every day from the CIA. During that briefing, Libby raised the topic himself, telling Schmal, the CIA briefer, Joe Wilson, Valerie Wilson. So Schmal has the name Joe Wilson, Valerie Wilson, in his notes on the brief from that day. And he has told us that he only takes notes on what the subject says to him. He does not take notes on what he is telling the subject. So he knows this is information he learned from Scooter Libby. So by June 14th, Scooter knew this information so well that he was informing his CIA briefer about it. June 23rd, Judith Miller, New York Times reporter. He had a meeting with Judith Miller, and during that meeting, Libby told her that Wilson's wife worked at the Bureau, a reference to the Counterproliferation Division at the CIA. Judith Miller has this in her notes, which we have possession of. 2 weeks later, on July 7th, another notable conversation, this one with Ari Fleischer, the White House press secretary. This was a memorable event for Ari Fleischer because it was his last day at the White House, and it was the only time before or after he had had a lunch alone with Scooter Libby. During that lunch, Fleischer's last day, Libby said he had information that was hush-hush on the QT and that was that Wilson's wife, Joseph Wilson's wife, worked at the CIA. And Mr. Fleischer is prepared to testify about that. Finally, the next day, on July 8th, Scooter Libby had another meeting with Judith Miller, this one at the St. Regis Hotel. It was a 2-hour-long meeting. And during that meeting, he asked to be identified as a former Hill staffer, which obviously was not the truth. He told her directly at that time that Wilson's wife worked at the CIA. So this was 9 conversations with 7 different people over the course of 1 month.
And so, Jesse, with that in mind, kind of showing how much this was in the forefront of Libby's mind during that 4-week period, let's just go back and talk again about what Libby told the FBI and the grand jury. So remember, Libby said he remembers learning about Valerie Plame and her CIA employment from reporter Tim Russert in a conversation on July 10th or 11th, as though he was hearing about it for the first time. He claimed Russert said to him, "Did you know Ambassador Wilson's wife works at the CIA?" And then according to Libby, Libby said, "No, I don't know that." And Libby said that he had a specific recollection of being surprised when Russert told him about Valerie. Now, we've spoken with Tim Russert, and Russert says that's not what happened. He says Libby called to complain about the show Hardball, and Wilson's wife never came up. And in fact, Russert said he didn't even know about Valerie Wilson and her employment at the CIA at the time of his conversation with Libby on July 10th and 11th. So he couldn't have told Libby about it on that day. Another thing that Libby told the FBI and testified to in the grand jury is that he told Matt Cooper on July 12th, reporters are telling the administration that Wilson's wife worked at the CIA. And Libby also says he told Cooper, I don't know if it's true, and I don't even know if he has a wife. We've spoken with Matt Cooper, and Matt Cooper says that's not what happened. He says that what happened is he asked Libby whether Libby had heard about Wilson's wife being involved in sending Wilson to Niger, and Libby said, yes, I have heard about that, which Cooper took as confirming the story. He recalls Libby saying nothing about having heard the information from reporters. So thinking about all that evidence that we've laid out, the charges that we're proposing are 1 count of obstruction of justice, 2 counts of false statements to the FBI, and 2 counts of perjury.
Well, first of all, a really impressive PowerPoint, especially for the government. I mean, that's practically a big law quality PowerPoint. So well done there. If I'm understanding you correctly, though, you are not recommending that we charge Libby with a leak of classified information. But don't we have evidence that he did, in fact, talk to reporters about Joe Wilson's wife working at the CIA? So why no leak charge?
Yeah, excellent question, and one we definitely want to answer for you. We looked very closely at 2 potential leak statutes. One that would require proof that Libby knowingly and intentionally disclosed the identity of a covert CIA officer, that's 50 U.S.C. 3121, and another that would require proof that he disclosed national defense information to someone not entitled to receive it. As you point out, the problem is not that we lack evidence that Libby discussed Valerie Plame's employment. In fact, the evidence shows that he did this with numerous people. The problem is proving exactly what was said in those conversations as concerns her employment and the classification of it. And so we feel that the evidence we have doesn't provide the clear, direct proof that we would want to establish all of the elements of either of those leak offenses beyond a reasonable doubt. But what the evidence does show clearly, in our belief, is that Libby lied about those conversations and repeated false accounts under oath. And that's why this case is ultimately about the lies, not about the leak.
But you're also proposing to charge obstruction. So if we're not going to charge Libby with the leak, is there an issue with charging him with obstruction, I assume, of the investigation, our investigation into the leak?
Yeah, another important question, and we don't think there's an issue with that. First of all, keep in mind, obstruction does not depend on proving that Libby committed the underlying leak offense. What it depends on is proving that he intentionally impeded our ability to determine what happened here. And also, keep in mind, right, this investigation was never limited to a single disclosure to Robert Novak. By the time we began our work in this investigation, there were multiple reports indicating government officials, plural, had discussed Valerie Plame's CIA employment with reporters. And a central objective of this investigation was to determine who knew about her employment, when they learned it, and who they told. The evidence that we presented here shows that Libby gave false accounts on those issues. He misrepresented what he knew, when he knew it, and how his conversations with reporters occurred.
But to that point, remember, we were investigating a lot of reports about Valerie Plame's name being discussed in the media by more than one government official. So when we took over the case, we thought there was a possibility that there was a conspiracy or a concerted effort, at least, by members of the administration, and that's what we wanted to get to the bottom of. And to do that, we had to know what the government officials knew and what they were saying to various reporters. And by lying to us repeatedly, he obstructed our ability and interfered with our ability to get to the bottom of the case. So we think the obstruction count is strong.
All right, well, let me move on to a couple of questions about how this case is going to be tried and what it's going to look like in a courtroom. And we all know that motive is not an element of any of the charges that we're talking about here, but we all know it's also important to jurors a lot of the time to understand why a defendant did what he did. So why did Scooter Libby, senior government official, national security advisor to the vice president, chief of staff to the vice president, why did he put everything on the line by lying about his conversations with reporters? What was in his head? Do we know?
Well, we have what we think is compelling evidence on that point. In Scooter Libby's files, he had at least 2 newspaper articles written, some published on the day of his interview and highlighted, which stated that the FBI was investigating a potential leak of classified information and reporting that they were investigating, the FBI was investigating whether Valerie Plame was undercover. We believe Scooter Libby was afraid that he had inadvertently provided this information to reporters and that he was now afraid that by confirming that he had had these conversations, he could be charged with violation of national security law.
Right. So even if he thought, I don't think I disclosed classified information, he was concerned. Maybe he said too much, right? So in addition to the articles about the investigation that we found in his files, some of which were underlined, and these were articles shortly before or right at the time of his interview. In addition to that, we also know, right, White House Press Secretary Scott McClellan was asked before Libby's interview, just a couple days before Libby's interview, if the president would fire anyone on his staff found to have leaked. And he said, if anyone in this administration was responsible for leaking classified information, they would no longer work in this administration. So our view is that Libby was focused on the possibility of charges relating to classified information and the possibility of losing his job. The motivation was self-preservation. He wanted to make sure there was no risk of either of those things. By claiming that he first heard about Valerie from Tim Russert rather than from government officials and claiming he forgot all these other conversations, he distanced himself from the disclosure of information about Plame. And he thought that story would make it less likely that he would face criminal or professional consequences. And then once he told the FBI that story, he faced a choice, right? He could correct the record before the grand jury, or he could repeat the false account. He doubled down and he chose to repeat it.
And so if we do go forward, even though we are not charging Libby with a leak of classified information, will classified information still be an issue? And how are we going to deal with that? I mean, we all know how the IC is about protecting their stuff, right?
Yeah, so we do think classified information is going to be an issue in this case, even though we're charging obstruction, false statements, and perjury, which should limit the extent to which it's an issue. The defense is likely to seek a lot of classified information in discovery, perhaps in part as a gray mail technique to try to derail the prosecution, but we have a well-established process for dealing with it under the Classified Information Procedures Act. Under CIPA Section 4, we can seek to protect classified information from discovery. The defense will have to show it's relevant and helpful in order to get that in discovery. We can argue it's not relevant and helpful if we believe it's not. And then even if the judge rules that it is relevant and helpful, we can propose unclassified substitutions. And then, to the extent that the defense wants to try to admit classified information at trial, they have to notify us in advance under CIPA Section 6A, and they have to argue its relevance and admissibility. We will argue why it's not relevant, why it's not admissible. To the extent the judge rules information is relevant, classified information is relevant and admissible at trial, we still get another bite at the apple under CIPA Section 6C. We can propose unclassified substitutions. So we have a plan.
All right, well, I'm convinced that we can go forward, that we can win at trial, and that a win at trial would be sustained on appeal. So I think we're solid there, but I think we need to consider an equally important question, which is, should we go forward? And why should we go forward?
Yeah, very important question. Just because we can charge, we want to make sure there's a reason for us bringing this case. And the reason, we think, is that our justice system absolutely depends on witnesses telling the truth. And that principle applies to everyone. I'd argue it's especially important when the witness is a senior government official who has a strong incentive to shape the narrative. We think the question here is pretty straightforward. When confronted with this evidence that we have, that a witness knowingly lied to federal investigators and a grand jury about matters central to the investigation, does the law require accountability? Given the evidence we have, we'd answer that by saying it's our responsibility as federal prosecutors to bring this case and let the jury decide. Not bringing the case and letting the jury decide would be an abdication of that responsibility in the face of this evidence.
Let's proceed.
A grand jury heard from these prosecutors and indicted Scooter Libby on 5 felony charges. Here in the district court, cases are assigned randomly. Judge Reggie Walton, a highly respected and experienced judge, got this case. And as soon as he received the assignment, he turned to logistics and legal challenges. We're going to turn to Judge Walton now and ask a few questions about that. Judge, Special Counsel Pat Fitzgerald held a nationally televised press conference in October 2005 to announce the charges against Scooter Libby. Fitzgerald compared what Libby did to throwing sand in the eyes of an umpire in baseball. He said anyone who goes into a grand jury and lies and obstructs has committed a serious crime. Were you concerned about the pretrial publicity here?
Yes, I was extremely concerned. I've always felt it was inappropriate for prosecutors to make statements about a case just because an indictment has been returned. When I was an assistant U.S. attorney under Earl Silbert and Chuck Ruff, that was an absolute no-no. You didn't do that. And that's the way I was taught as a prosecutor. So yes, I was extremely concerned for a number of reasons. One, obviously it could have an impact on the potential jury pool that would hear the case. And I just thought it was inappropriate to put out the the government's position as to the defendant's culpability, because it could potentially deny him the opportunity to receive a fair trial.
This is a defendant with very close ties to the White House, to President Bush and Vice President Cheney, at a time in the country when the administration was very unpopular with most residents here in Washington, D.C. How did that pose some additional challenges for you in terms of jury selection?
That was a significant concern, because I did appreciate, and it became a reality, when we went through the process of trying to pick a jury. It in fact took about 4.5 days in order to impanel a jury because there were so many potential jurors who felt that they could not be fair and objective in the case because of the Iraqi war and also their perception about the Bush administration and in particular Vice President Cheney, which Mr. Libby worked for him. He's one of his top aides, so that was a significant concern. And one of the things I did, having read about the press conference that Mr. Fitzgerald gave, I decided that at that first appearance, when they would appear before me, that I would not sanction or say anything to the government about what had happened, knowing that probably the defense would do the same thing because there was a lot of media coverage surrounding the prosecution. The courtroom was packed with media, and I knew that there probably would be questions of defense counsel when they left the courtroom. So I didn't say anything, knowing that they probably would make their statements, and I didn't say anything because I was going to give them the opportunity to sort of level the playing field.
And speaking of all those reporters, we're getting ready for trial here in this courthouse. What kinds of precautions and planning did you do to account for the media coverage of this trial and some of the security challenges with the defendant and many of the witnesses?
Well, I had never handled a case with the amount of media coverage involved, and I knew that the judge who had handled the Oklahoma City bombing case had, in fact, confronted some of the same challenges. So I contacted him, and he graciously agreed to speak to me and gave me some insight as some things that he had done and things he recommended that I do, and I adopted a lot of that. And I felt it was appropriate to impose, in a sense, a gag order. So after the defense had the opportunity to make their statements after that first appearance to the media, I let counsel, both the government and the defense, know that I was not going to tolerate either side making comments anymore to the press, and they did abide by that. I thought that was critical. In reference to the jury itself, as I said, it took about 4.5 days to impanel that jury, and the courthouse was surrounded by media. I think we had over 100 media outlets who wanted access to the courtroom. And I knew, obviously, the courtroom could not accommodate that many individuals, so for the first time in the history of this court, we created a media room. We took over one of the magistrate judge's former courtrooms, and we turned it into a media room where the media personnel had the ability to have immediate contact with their newsrooms from that facility, which is still an integral part of the courthouse.
And thank you for that, Your Honor. We sure have used it a lot over the last few years in particular. We're going to transition to the defense side of the case. While preparations by Judge Walton and others got underway here for the trial, Scooter Libby's defense team began to chart their own strategy. They focused on several critical issues, including whether the special counsel had been appointed properly under the U.S. Constitution, and on the hectic pace of Scooter Libby's job, whether he could be expected to have a clear memory of his conversations with the press and others. We're going to listen in now to some of those key moments for the defense.
The investigation that Scooter Libby was accused of obstructing focused on two questions. One, who leaked the employment of Valerie Plame, Wilson's wife? And two, whether that was a crime. Well, they got a lot of answers to the first question. Richard Armitage, who was Deputy Secretary of State, was the first person known to tell a reporter about Wilson's wife's employment. He told Bob Woodward, who didn't think it was important and never wrote anything. And then he told Bob Novak, who did, as we learned, write something. Karl Rove was the Deputy White House Chief of Staff for President Bush. He told Matt Cooper of Time magazine, and he confirmed the fact to Robert Novak. Ari Fleischer, you've heard about him from the prosecution. He was the White House press secretary. He told Walter Pincus of the Washington Post. He also told David Gregory of NBC News while on a trip to Africa. There's somebody else, and probably multiple people, who told Judy Miller. We know that because she has notes in which she has notes about Valerie Plame, and I'll come to this later, many times, none of which came from Scooter. But you know, none of these people, well, the second question, was it a crime? Nobody was ever charged with a crime. These people who did the leaking uniformly and with good reason said they had no idea she was covert or classified. She was just another analyst out at Langley like thousands of other CIA employees. So there was never any basis really to charge those people who in fact leaked. And by the way, as to whether she was covert or classified, the prosecution argues that, well, Libby thought she might have been. Well, that's a theory without evidence, frankly. There's no evidence of that whatsoever. What happened was we wished to explore whether she was covert or classified. We asked for discovery. We didn't get any discovery. The judge ruled that it was irrelevant, as in fact it should have been, to the perjury charges. He must have instructed the jury half a dozen times, maybe more, that the issue was irrelevant and the jury should not consider it. So the investigation did arrive at the answer to both questions. And we all know it was not alleged in the Libby indictment. It was not proven. We never saw any evidence that in fact she was covert or in fact, well, let me talk about the two reporters who claimed that Libby leaked. So Matt Cooper from the Post, before he talked to Scooter Libby on the telephone, he had already talked to Carl Rove and learned about Wilson's wife's employment. He asked Libby about it. He claimed in his trial testimony and to the grand jury that Libby confirmed that without reservation. Libby, on the other hand, you heard him in the interview, but his testimony was he had heard that from reporters, but don't know if it's even true. Well, we found some notes that Matt Cooper had typed while he was talking to Libby on the telephone. And they're full of typos, they're full of incomplete sentences, they're full of misspellings. But when you look at some other things that Matt Cooper typed, you can see some of his habits, like his fat finger. He types an R when he means an N. He types had, H-A-D, when he means heard. And while Matt Cooper was on the stand, we went through every word of this sentence, which Cooper, by the way, says he doesn't know what this is about. What this sentence says is heard something about the Wilson thing, meaning Wilson's wife, and not sure if it's even true. That's very close to what Scooter said to the grand jury and to the FBI. Well, let's talk about Judy Miller. She's a piece of work, admits a very poor memory, but she relies on notes. She had a notebook full of random notes. Sometimes you don't even know what they relate to. But the prosecution in its presentation here today said that, that Judy Miller said that Scooter said that Plame worked at the CIA. Judy Miller never testified to that, actually. What she said was, let's look at these first notes. It says, wife works in bureau, ? In parentheses. Well, she admitted that she often makes notes to herself in her notebook, things to ask people, whether it's Libby or somebody else. There are no bureaus at the CIA. Nobody ever told Scooter Libby that Wilson's wife worked in any bureau. And Anyway, the other thing was, I said before, Judy Miller's notes have numerous, I counted 5 entries with Valerie Plame's initials or name. Valerie Plame's initials or names. Now, again, you can't read these, but in the first red box is VF, second red box, Valerie Plame, third box, Joe Wilson, Valerie Wilson. There are 2 other entries, too, which it didn't make the slide. But when we're cross-examining Judith Miller, her testimony was she doesn't know a single person who gave her any of this information other than Libby, even though she admits that none of these came from Libby. Not a single one. But yet, can't recall. So those are the only 2 reporters that claimed that Libby leaked. And our position was, number one, he didn't say anything to Matt Cooper other than what was obviously true. When Matt Cooper asked, yeah, I've heard that, but I don't even know if it's true. Or Judy Miller, he said, they never talked about the wife in his meetings with Judy Miller. Well, let's go back, because at the start of this case, we made 2 important motions. One challenged the constitutionality of the appointment of Pat Fitzgerald, special counsel, and I'm going to ask Alex Walsh to argue that motion.
Yes,
please.
well, thank you, Bill. And as a second-year associate at your law firm, I was honored to have been given the opportunity to develop this argument and to now present it to his honor. May it please the court. Alex Walsh for the defendant, Mr. Libby. Your Honor, our motion to dismiss raises a single question. Was Patrick Fitzgerald lawfully appointed to his role as special counsel? The answer, he was not. That conclusion, Your Honor, follows directly from the plain terms of the Appointments Clause to the Constitution. That clause requires that the most powerful officers in the executive branch, what we call principal officers, that they be nominated by the president and confirmed by the Senate, that they go through that process that is so important to our separation of powers. The requirement's not a mere formality, Your Honor. It's important. It's a critical and democratic constraint on the exercise of executive power. Now, the executive branch has lots of officers. So how do we know a principal officer when we see one? Well, the Supreme Court is very clear about this. There's an opinion, which we've cited in our brief, Your Honor, called United States versus Edmond. And what it says is you have to ask, is there anyone supervising this person? Does this person have to answer to anyone? If the answer is no, no supervision, they don't have to answer to anyone, then that person is acting as a principal officer, and they should have been confirmed by the Senate. Well, this description I've just given, Your Honor, this fits Patrick Fitzgerald exactly. By the express terms of his appointment, the letter appointing him, he answers to no one. The letter said, and I quote, that Mr. Fitzgerald will operate independent of any supervision or control of anyone in the Department of Justice or anywhere else. Now, that unsupervised exercise of power would be okay if the Senate had approved it, but as we know, it did not. The court might ask, well, what does this matter? Why does it matter that no one is overseeing what Mr. Fitzgerald is doing? What's the harm? Well, aside from violating the Constitution, one example immediately springs to mind, and that is this highly prejudicial press conference that Mr. Fitzgerald held in announcing the indictment. He went on for 66 minutes in that unnecessary press conference. And during that press conference, he repeatedly violated DOJ's rules about public statements by prosecutors, rules that are designed to ensure fairness for criminal defendants, rules that are designed to protect the presumption of innocence. Those rules were violated here. He stated as a fact that Mr. Libby had lied to the FBI and had lied to the grand jury. He acted as if that guilt was already established, and it was not. He also declared that Mr. Libby was the first official to disclose Ms. Plame's identity to the media. That accusation is not in the indictment, and it's not even true. In fact, it's demonstrably false, and the prosecution team knew it. Now, in any other case, a defendant in Mr. Libby's circumstance could have gone to the prosecutor's supervisor. He could have asked that these improper statements be corrected so that the public and the potential members of this jury would be disabused of these misstatements. Here, Your Honor, Mr. Libby had no one to ask. There's no supervisor to address Mr. Fitzgerald's misconduct in that improper and highly inflammatory press conference or otherwise, or in his decision to even bring this indictment. Your Honor, the Appointments Clause was written to prevent precisely this situation, a situation where one person who was not confirmed by the people's representatives holds the full, unchecked, and unsupervised prosecutorial power of the U.S. It's improper, it's unconstitutional, and it should not be permitted to stand. Thank you very much, Your Honor.
Well, I have read your submissions. Also, the government filed a submission opposing your motion to dismiss. My law clerks and I have done extensive research. And yes, we are familiar with the opinion that you cite, the Edmonds opinion. And one could argue that it does include language that would support your proposition. But there also was another authority from the Supreme Court, the Morrison decision. And that opinion, I think, cuts against the argument that you make. Obviously, in both of those cases, the court says that there are a number of factors to be considered, although they focus on different factors. And yes, the fact that someone has the authority to control an official is an important factor to consider in whether that individual is a principal official as compared to an inferior official. And while one could argue that the two letters that were written by Mr. Comey appointing Mr. Fitzgerald to handle this case was a significant authority that was given to him, it was envisioned in the statute, for example, that created the Justice Department, that there could be circumstances where the Attorney General could delegate some of his authority to other officials. And in this situation, we're talking about the Attorney General, Mr. Ashcroft, having decided that because of his close association with the White House, that it was appropriate for him to recuse himself, and he therefore appointed, or at least designated, Mr. Comey as the Deputy Attorney General to act in his stead. And Mr. Comey made the same assessment, that he was so close to the White House and to Mr. Libby that he felt it was appropriate that he also recuse himself, and he therefore opted to delegate the authority to prosecute this case to Mr. Fitzgerald. Now, I think it's important to appreciate that Mr. Fitzgerald was the attorney, was the U.S. attorney in Chicago, and therefore he was going to still be subject to the authority of Main Justice, in that there are rules and regulations that place restrictions and constraints on what the U.S. attorney can do. And while it can be argued that conceivably there was no supervision over him, the reality is that Mr. Comey did not abdicate his authority to remove Mr. Fitzgerald from presiding over this or having the responsibility of prosecuting this case if, in fact, he did not comply with the restrictions imposed on the conduct of prosecutors in the prosecution of cases. So while I appreciate the argument that's being made, and I think it resonates to some degree, in my view, the government has the better position. And accordingly, I would conclude that under the statute that created the Justice Department, that there clearly is the authority for the Attorney General to appoint others to handle matters that otherwise he or she would have the responsibility of handling. And as I say, I do believe that despite the argument being made that there was no supervision of Mr. Fitzgerald, that was in place. I don't think that's true, considering his status as a U.S. attorney and the fact that he still had to comply with the rules and regulations of the Justice Department. So while you present a convincing argument, I nonetheless think the government has the strongest argument, and therefore I don't think under the statute that created the Justice Department that the appointment or the delegation of authority was inappropriate. And under the appointment clause of the Constitution, it's my view that there was no violation by the delegation, and therefore I would deny the motion to dismiss.
Thank you, Your Honor.
All right, well, unfortunately, we lost our motion to dismiss. If only it was a few years later, we could have prevailed. So let's turn to trial. Our main defense, of course, is going to be that his memory, he just didn't remember what had happened. And unfortunately, the government has quite a few witnesses who will try to say that Scooter already knew. So I think what we need is an expert about the reliability of memory.
Great idea.
Thank you. So we made a Daubert motion to admit testimony, and with the court's permission, I'd like to briefly argue that.
Yes.
Your Honor, this case turns on memory. The jury must decide here whether Mr. Libby lied or whether he just misremembered what happened when he was talking to the FBI and when he was in the grand jury. So the jury needs to understand human memory and how it actually works, and that's where the science comes in. We offer the testimony of Dr. Robert Bjork as an expert in cognitive psychology and human memory. Now, the government doesn't even try to quibble with his qualifications, given that he has 4 decades of experience and has authored over 120 peer-reviewed articles. What they do challenge under Daubert is the reliability of his opinions and whether they're a good fit for this case, and so that's where I'm going to focus. So first, we think there's no question that Dr. Bjork's opinions are reliable. This is not new science, it's not junk science. Memory experts have been admitted in their opinions in courts across the country. And in our disclosure, we make clear that his opinions are reliable because they're based on peer-reviewed research, the literal gold standard for when the court should act as a gatekeeper to permit it to come in. Now, second, Dr. Bjork's testimony fits this case and will help the jury. Dr. Bjork will explain to the jurors that I think something none of us really understood until we learned about it, that the human memory doesn't just record events and then play it back on demand. In fact, he'll explain that our memories are vulnerable to interference and divided attention to events both before the event you remember and after. And given that Mr. Libby was the chief of staff to the vice president, we know that his attention was divided among many issues as he dealt with national security before and after this event. And finally, Dr. Bjork will explain that memory errors can cause someone to incorrectly reconstruct not only what someone says in a conversation, but who said it. And that is crucial here. The government's objections really go to nothing more than weight, not admissibility. And they will have the chance to vigorously cross-examine Dr. Bjork. The jury does not know about this. It's well outside the ken of the average juror, and it will be extremely helpful in deliberations. And so we ask that you admit these expert opinions. Thank you.
Again, I've read extensively the submissions made by both the defense and the government, both well done, and to some degree convincing. However, in reference to your expert, there's no question he is extremely qualified, and that the testimony he would provide, if he were permitted to testify, would be predicated on scientific research. And from that perspective, I can't take issue with the fact that he has the sufficient qualifications to testify as an expert. The problem, as I see it, is that his expertise, as it relates to the ability of memory to recall events, is predicated on identification evidence. And that's what all of his scientific research relates to. And I would submit that there is a difference, as the government points out, between identification evidence and memory of identification regarding a traumatic event, which is what primarily he has examined, and whether when somebody experiences such an event, they can recall the event. And I think that's very different than the situation that we have here. And the reality is that most, fortunately, people who are going to be a part of this jury panel would not have experienced the circumstance where they were subject to a crime, a traumatic event, and therefore had to recall the event subsequent to that. Most individuals, however, do appreciate, because on our daily basis, we have to make assessments as to whether or not we recall events, not in the context of a traumatic event, but in the context of just remembering something that took place. And I think the average person is going to appreciate that memories can be faulty, since all of us have to go through that process of assessing whether we have a memory of an event. And in my view, it's not necessary for the jury to have that assistance in assessing whether, based upon the testimony that is presented during this trial, whether Mr. Libby in fact had a memory of the event, and therefore when he indicated the things that he said, he knew that he was providing false information. So while you make a very convincing argument, in my view, I would be circumventing the ability of the citizens of the District of Columbia to make an assessment on a factual issue that I think they have capacity to make, and therefore expert testimony will not be necessary to their assessment as to whether or not the government has proven its case beyond a reasonable doubt. So the motion will be denied.
Thank you, Your Honor.
So,
Now we turn.
without a memory expert, what can we do about Scooter's memory and try to convince the jury that his memory was in fact what he said it was? Well, the obvious thing is we can go through every government witness and prove at some point they misremembered, totally didn't remember. And
I have some good examples that I've found in my research.
why don't you explain a couple of them?
Okay. The first one involves the beloved Tim Russert. It turns out that he's had failures of memory repeatedly. He was widely criticized for how he covered the Monica Lewinsky matter, and he was actually called up on that by a reporter from the Buffalo News who said that he was an embarrassment to himself and his profession. He was asked about that by a Washington Post reporter, and he said, "Oh, yeah, but he issued an apology." And the reporter said, "Well, didn't you urge him to issue that apology?" And he says, No, I didn't. He issued it on his own. Well, the Buffalo News saw this and very shortly thereafter said, "That's not true. Several staffers remember that you called repeatedly saying you got to issue an apology." And after that was published by the Buffalo News, Russert came forward and said, well, he was sorry. He just plain didn't remember making those 2 phone calls. He just plain didn't remember. So that's one example. Another example is related to Grenier, who, interestingly, when he was first in the grand jury, said he has no recollection of ever discussing Valerie Plame with Scooter Libby, of not even knowing who Valerie Plame was or what her status in the CIA was. The next time he testified, he provided what the prosecution has highlighted as very important to its case, saying that he was the one who told Mr. Libby that Ms. Plame was covert. You know, what happened in between those two things, Bill, is that the CIA became concerned that the Vice President's office was trying to blame the CIA for the inclusion of the 16 words in that State of the Union. So that was pretty interesting, how his testimony completely changed between those two things.
Speaking of memory, Ari Fleischer, you've heard about Ari Fleischer, the White House spokesperson. He says definitely he never told Walter Pincus about Wilson's wife. Walter Pincus will testify, and he has notes that show without any question that Fleischer did tell him. Judy Miller. I said this before, but her notes have 5 different times that somebody told her about Valerie Plame or Valerie Flame or Valerie Wilson. But when asked on the stand, she can't remember a single person, not a single person who told her any of that information, other than, of course, Libby. And she admits that these entries have nothing to do with Libby and didn't come from Libby. She also says that she didn't write anything. Judy Miller never wrote anything but about the wife, but she claims that she proposed to Jill Abramson, her editor at the New York Times, that she write a story. Jill Abramson will testify, we'll put her on the stand, never happened. So, and those are just a few of the more important instances in which we can show that the prosecution witnesses have memories, failures, without the necessity of an expert. So we're just about out of time, but I do want to talk about the decision that Scooter should not testify. Alex, you want to deal with that?
Yes, just briefly, I'd say that, one of the things we have to decide, Bill, here is whether Scooter should testify. And I think we've come to the conclusion that that he will not testify, that he'll exercise that right. And, the prosecution chose to play 6 full hours of his grand jury testimony to the jury, and the jury got to hear that. I think he sounded very credible, like he was doing his absolute best. I also think, we've discussed concerns around perjury trap here and so forth, that having Scooter take the stand once again and being subjected to cross-examination by Mr. Fitzgerald, who's got that skill, we're just going to create more opportunities for the government to point out inconsistencies, because as we've seen from the examples we've given, it is hard to keep all of these facts completely straight. So I really don't think it's a close call.
At the bottom, what did Libby supposedly obstruct? He wasn't the leaker. To Novak wasn't the leaker to anybody that published anything. He didn't know who was the leaker. If he had failures of memory, that's not a felony. That's it.
30-second rebuttal from the government on the memory issues of the other witnesses. People's memories are imperfect. That doesn't matter for our case. This is not a situation where Libby's account is merely different from somebody else's recollection. His account is contradicted by a mutually reinforcing body of evidence, witnesses, contemporaneous notes, documentary evidence that consistently shows he learned about Valerie Plame from government officials before the Russert conversation and discussed her with numerous people.
Thank you. And now we turn to the jury. In all, this trial lasted 7 weeks from jury selection to jury verdict. Scooter Libby did not testify, but several Washington, D.C. reporters did. Jurors received instructions from the judge, deliberated for 8 days. On March 6th, the verdict came. Guilty on counts 1, 2, 4, and 5, not guilty on count 3. After the verdict, some of the jurors talked about the deliberations and how they felt about the credibility of some of these witnesses. We're going to listen in now on what might have taken place during deliberations, remembering that our 3-person jury today will be doing in 10 minutes what it took the real jury 8 days to do.
If I could just add before they discuss their deliberations, one of the things that I decided to do because of the amount of press coverage and because of the number of reporters who encircled the courthouse was to partially sequester the jury. I had considered complete sequestration, but I decided that that would just make it more complicated and difficult to impanel a jury. So I did partially sequester them, which resulted in the Marshal Service picking them up at a particular location every day, taking them to another location every day so that they would not have contact with the media. They were never out in the public area of the courthouse. They were always back in the judge's area. We provided breakfast for them, and we provided lunch for them. We provided newspapers that they could read so they could stay abreast of things other than what the trial was about. I had several law students from the law schools who would come every day, and they would review the new, I think it was the New York Times, the Washington Post, and the USA Today, and to remove anything regarding the Iraqi war and anything regarding the trial, so at least the jurors would have the opportunity to have some contact with the outside world during the course of the trial.
All right. Why don't we start focusing on Libby's conversation with Tim Russert of NBC News. According to the indictment, Libby knowingly gave false information to the FBI
about his conversation with Russert on July 10th or July 11th. Libby told the FBI that Russert asked Libby if he was aware that Wilson's wife worked for the CIA. Libby said he told Russert that he didn't know that, and that Russert had replied that all the reporters knew. Libby said he was surprised by that.
So Libby's saying that Russert brought it up to him like it was some news, and that's when he first learned it as it's something real.
Right. And now here's what he told the FBI about his conversation with Cooper. The reporters were telling the administration that Wilson's wife worked for the CIA. Libby also said he told Cooper that he did not know if that was true.
So he's telling the FBI that what I'm hearing is from other reporters, but I'm not sure that it's true. And he's hedging that it's coming from him. What does the November FBI interview say? Did he change his story then?
Nope. He said the same thing in November.
But he admitted, and he had notes to show, that the vice president told him on June 12th that Wilson's wife worked for the CIA in that division. So he acknowledged the notes to the FBI. He just said that when he spoke to Russert a month later, he had completely forgotten about that earlier conversation with the vice president.
Yeah, right. He forgot something the vice president of the United States told him personally.
That's what he said.
Okay. In his defense, he is the chief of staff to Cheney. He's handling nuclear war, national security assessments, classified briefings, the war, the State of the Union. I think he had a lot on his plate. And, maybe the detail about Plame didn't matter when he heard it.
Yeah, that's all true, but we have to consider the timeline the prosecutors gave about what Libby knew before his phone call with Russert. In addition to the conversation with the vice president around June 12th, between June 11th and July 8th, less than a month, there were 8 other times that he was informed or discussed the fact that Wilson's wife worked for the CIA, including 3 times that Libby told that fact to somebody else. If I'm told something once, I might forget it. If I'm told something many times, I'm less likely to forget. But if I myself tell it to somebody else, I'm even less likely to forget that I knew it.
Can I just say something off the legal track for a second?
Yeah, sure, go ahead.
So Libby's lawyer said in opening statements that the White House had sacrificed Libby to protect Roe, and that Libby was the fall guy. And I have to tell you, I keep wondering if that's true and if he was protecting someone. It does not explain why he might have lied. I mean, he lied because someone asked him to, or because he was loyal to some people above him.
Yeah, this is something we've discussed so much, right? What are we doing with this guy? Where's Rove? Where are these other guys?
But remember, this wasn't just about Novak's call. The Time magazine article came out about 3 days later. Cooper and Dickerson reporting that government officials had told Time that Wilson's wife worked at the CIA. That's the same Cooper that Libby called from Andrews Air Force Base. And then the Washington Post in late September. 2 top White House officials called 6 journalists. 6.
True. 6 journalists, that's not a slip, that's a campaign.
Well, wait a minute. It's obviously not all on Libby. In fact, the government's making no claim that Libby was the source for the public disclosure of the identity of Wilson's wife as working in any capacity for the CIA. It's not about who leaked the information. It's about whether he was truthful in his FBI interview and when he testified before the grand jury.
Yeah, but that's my point, which is exactly why the I forgot story is so hard to swallow. He was in the middle of it all. His own 9 conversations in a period when the administration was calling reporters up and down the dial, and he wants us to believe he forgot?
True, but we can't convict him for the broader campaign or acquit him because we feel bad about him being the only one in the room. Our charge is Libby, what he told the FBI and what he told the grand jury.
Okay, can we look at count 3, the Cooper count? I'm really troubled about this. I keep reading the indictment language 2 different ways. is the charge that Libby never said what he claims he said to Cooper, meaning he actually confirmed Plame's CIA status without any hedge or qualification? Or is the charge something about the context?
Well, because Cooper's version is that Libby said that he had heard that Wilson's wife was with the CIA, there was no qualification. Whereas Libby said that this is what reporters are saying, but he didn't know if it was true. That difference seems really subtle to me.
All right, AJ, you seem pretty skeptical that when he talked to Russert, Libby would have forgotten what he heard and discussed, 9 times? I get that, but at the same time, we're talking about someone's memory. Everyone's different in their ability to remember things. And at the time, he was so busy dealing with so many huge other important things. And I should add, to prove its case, the government's relying on Russert's testimony and his memory, and Cooper's testimony and his memory. So it's not just how good is Libby's memory, it's also how good is the memory of the government witnesses. And the government has to convince us beyond a reasonable doubt. I'm just not as sure as you are about this. I'd like to get more direction from the judge, I think, about how we should be thinking about this.
So should we send a note?
Yeah, we should send the note. Let's ask, does the government have to prove it was not humanly possible for someone to recall an event in order to find guilt beyond a reasonable doubt? The judge.
Well, I've already given you an instruction regarding what the government's burden is, and it's proof beyond a reasonable doubt. I will repeat that instruction for you again, and that's what you're controlled by. I can't give you any more detailed instruction regarding what that standard of proof is. So I'd ask that you reconsider what I told you in reference to that standard of proof and that you apply that.
It doesn't matter whether it was humanly possible to forget, though. The question is whether he forgot. And as I see it, everything we laid out in Post-it notes and put on those walls said he didn't forget.
All right, well, that answer wasn't that helpful, but let's try again. On another set of issues,
Well, you must be an expert on memory.
All right, so I think we've got 3 questions for the judge here, all about count 3. And this is, we've been over the instructions. This is on page 74 and page 75 of the instructions. So I'm going to write these out. Question 1, is the prosecution alleging that Libby did not make the statement to Cooper as presented in the indictment? Or is the allegation that Libby did know that Wilson's wife worked for the CIA when he spoke to the FBI?
Okay, I have one. Okay. Question 2, same thing, but different angle. Did Libby know that Wilson's wife worked for the CIA when he made the statements to the FBI? And crucially, that Libby did not know if this was true.
And question 3, I think, in determining count 3, are we allowed to consider Mr. Libby's grand jury testimony?
Yeah, that's good. All right, let's ship it off to the judge, see what we get.
Well, in reference to your first 2 questions, you're asking me to make factual determinations for you. And as I told you in my instructions, I'm the judge of the law. I'm not the judge of the facts. That is exclusively within your province as the jury. So I cannot answer those questions. You have to assess those questions based upon the evidence that was presented during the course of this trial.
So not real helpful again.
That didn't help.
And your third question again?
Yeah. So the third question is, in determining count 3, are we allowed to consider Mr. Libby's grand jury testimony?
You can only consider the testimony that was presented during the course of this trial, and to the extent that there was, in fact, evidence presented regarding his grand jury testimony, you can only consider that in your assessment here, because he's not charged with having said anything inappropriate or incorrect to the grand jury, that you can obviously consider it for what purpose it was presented during the course of this trial.
So I take it from that the question is narrower than we thought. The question is, did he accurately describe his conversation with Cooper to the FBI, and that's it?
And on that narrower question, Cooper's own account had some uncertainty. He didn't put a second confirmation in his article that day. If Libby had given him a clean yes, I confirm it, Cooper absolutely would have used it. His notes on the specific phrasing were ambiguous. I can't get to a guilty beyond a reasonable doubt on that specific count.
Agreed.
Well, let me correct. I made a mistake. You can consider his grand jury testimony, obviously, in your assessment as to whether the government has proven its case. Yes.
Yeah. All right. So are we all thinking not guilty on count 3?
Yes.
Yes.
All right. I guess we're as ready as we're going to be. I mean, to reach a verdict on all this, right?
It's been 8 days.
Yep.
Yeah. All right. So count 1, obstruction of justice. Guilty.
Yep.
All right, guilty. Count 2, false statements to the FBI about the Russert conversation. Agreed.
Yep.
Count 3, false statement to the FBI about the Cooper conversation. That's on you.
You good?
I'm good.
Reasonable doubt. Cooper's account had enough uncertainty that we just can't get
Yep.
there. All right. Count 4, perjury before the grand jury, the Russert conversation. Guilty? Yeah.
Yes.
All right. So count 5, perjury before the, count 5, perjury before the grand jury on the Cooper conversation. Also guilty?
Yes.
All right, we've got 4 guilty, 1 not guilty. I'll send this to the judge. And we send a note, the jury has reached a verdict in each of the 5 counts. All this time, all this work, all these post-it notes. Here we go.
All right.
Judge Walton imposed a sentence of 30 months on Scooter Libby, but that was not the end of the story. President Bush commuted the sentence in July 2007, before Libby ever reported to federal prison. Libby paid a fine of $250,000. He served 2 years probation and got disbarred from practicing law. In time, he won back his law license, and in 2018, President Donald Trump issued him a full pardon, saying he had been treated unfairly. Judge, this was quite a roller coaster from sentencing to pardon. How do you look back on those events?
Well, one of the things I was told by one of my colleagues, Judge Lambert, when I was assigned the case, he said the reality is that there's a good chance that Mr. Libby will ultimately be pardoned. He said, but it's not your concern. That's something that the executive branch has the authority through the president to do. And your obligation is to fulfill your obligation as a federal judge. So don't worry about the ultimate result. However, the reason I imposed the sentence that I imposed was because, and it was a tough sentence. Any sentence is very difficult, and this sentence was particularly difficult because Mr. Libby had an exemplary background. He had been a lawyer in Philadelphia. He had been involved in community outreach efforts in Philadelphia. As far as I know, he had been an outstanding White House member, and he had no prior history of any illegal behavior. I received probably about 100 letters from individuals in reference to what sentence I should impose. And one of the things that the defense requested in reference to the letters, because many of them came from very prominent individuals, was that I place those letters under seal, which I denied because I thought the public would have a right to know exactly what factors I considered in deciding what the appropriate sentence is. So I denied that request. At the time I imposed the sentence, the United States sentencing guidelines, which had been mandatory, had been declared unconstitutional as mandatory by the Supreme Court. So they were only advisory. The administration was not happy with that decision, and therefore they had requested that the Congress make what had been the mandatory minimum sentence. They had requested that all of those sentences be made mandatory sentences by Congress, which Congress had not done and did not ultimately do. And my feeling was that the conduct that Mr. Libby had been convicted of was extremely serious conduct. So despite his exemplary background, having disclosed what I thought probably was knowledge that he was disclosing the identity of somebody who worked for the FBI, for the CIA, and I don't know, and nobody ever knew exactly what her status was, but nonetheless, he had disclosed her identity, putting her potentially at risk, and if she was a CIA agent or in some other operative position, putting anybody who she would have had contact with potentially at risk also. So weighing his background against what he had done and what the administration was saying they thought would be an appropriate sentence for this conduct, which was 30 months, I gave him a 30-month sentence consistent with what the administration itself was saying they thought would be appropriate for the conduct he was convicted of. Was I dismayed by the commutation of the sentence? Yes, I thought it should not have been commuted. Unfortunately, or fortunately, for whatever perspective you have, the president does have that authority, and he did exercise that authority in President Bush. I was troubled, however, because he said he was commuting the sentence because my sentence was too harsh. At the same time, he was asking Congress to make that sentence a mandatory sentence. So the duplicity in that position I found extremely troubling. But nonetheless, that's how our system works, and he commuted the sentence, and Mr. Libby still had to pay the fine, which I think was a $750,000 fine, and he still had to serve his community service as a part of the probationary sentence that ultimately his sentence became. As far as what ultimately occurred, as far as the pardon was concerned, as a judicial officer, yes, I was very troubled by that because we are asked to impose sentences on individuals who've committed conduct a lot less serious than what the conduct was in this case. And it becomes very difficult when the community starts to believe that we don't have a fair and just system, and that the potential penalty that you're going to face is going to be predicated on who you know and what your status is in society as compared to what you did. And while I respect the pardon authority because there are people who have changed their life, they've done something exemplary in life, and therefore I think it's appropriate to have grace in reference to individuals under those circumstances. But I'm very troubled by the fact that it seems like pardons are being given just because the individual has some association with the administration or with others who are associated with the administration. As a result, the average Joe has to think our system is not fair and just, which is understandable, and I find that very disturbing as a judge.
Thank you to the judge and these distinguished lawyers, and thanks for your interest in the Historical Society. We'll have refreshments downstairs in the atrium on the ground floor. We hope to see you there. Thank you.